Hello and welcome to our webinar today. My name is Jenny Sutton. I'm the Executive Director for the Texas Self-Storage Association and want to welcome you to the second webinar in our series related to the coronavirus crisis. Most of you were probably on board with us last week when we talked about operational decisions, whether or not to keep the facility open, whether or not to have a manager in the office. If you did not see that webinar, I encourage you to view it. It is posted on our website at www.txssa.org. We have a link from the homepage. And today is a different subject, and we're not going to go back and rehash those decisions that people were talking about last week. Today we have three attorneys joining us. Our promotional materials said that we had Jason Kohout. I didn't even have a chance to check on the mispronunciation on these names. So hopefully if I murder anyone's pronunciation, they will correct us when they introduce themselves or when they greet you as a speaker. But Jason was our primary presenter, and he has asked two of his fellow attorneys from the firm to join us today, and that's Carrie Hoffman and Tim Boydman. So I'm going to say just one or two things, and then I'm going to kick it over to our presenters and let them get into the nitty-gritty. I've had a lot of emails, a lot of contact from people about the CARES Act, about FFCRA, and a lot of the folks in our industry in self-storage are wondering if these programs really apply to them. And we'll get into the basics in just a moment as to who qualifies and what you have to do to get funds. And that's what our experts are here for. So if I could ask those of you who are joining us today, and there are several hundred, if you could hold off on your questions in chat until you see if the question has been addressed. I've already spoken with Jason in advance about some of the things that were coming up a lot, and we hope to give them a chance to address those questions first. If they don't address your question, or if the material that's been presented is very unclear to you or in any way unclear, that's the appropriate time to send through your question. There are two modes in Zoom. You can chat, which is something that everyone will see, or you can send in a question through the Q&A module. And you'll have to find that on your device. People are using a number of different devices and things appear in different places. If you click around a little bit, you can usually find it fairly quickly. So questions for questions, chat for chat, if that makes sense. The chat is going to be seen by everyone. The questions are going to be seen by those of us who are going to be answering the questions for you. So without further ado, I'm going to turn things over to our presenters, starting with Jason. And Jason is a partner and a business lawyer practicing with Foley and Lardner, LLP. I'm going to tell you about each of our presenters first, I think, and then we'll turn it over to Jason, and then he can kick it over to the other attorneys. Jason's work encompasses all area of tax and corporate law, and he focuses on the area, especially of tax-exempt organizations like TSSA. Most of you who are viewing today are probably not tax-exempt organizations, unless you have a foundation or charitable group that you work with. Other things that Jason's involved in, he focuses on charitable giving, political and lobbying law, advising individuals, closely held businesses with regard to estate planning, and all related issues. He is a member of the firm's estates and trusts, taxation and government and public policy practices, and the healthcare industry team. That might be the longest team name I've ever seen. And that's wonderful. This firm also has a coronavirus task force created, which is the reason we were able to get them to be with us today. They're being very proactive in trying to help their clients. Our second presenter is Carrie Hoffman. She is also with the same firm of Foley and Lardner, LLP. She is in the Dallas office. She's an attorney there, and she represents and counsels major employers nationwide in all areas of labor and employment law across a wide range of industries, including retail. Carrie is highly regarded for her experience with wage and hour issues, as well as employment discrimination and retaliation claims. She regularly reviews and drafts employment agreements, such as covenants, employment agreements, such as covenants and non-competes, and advises clients on a wide variety of labor and employment issues. So she's going to be our employment expert today. Tim Voigtman is our third attorney today. He is with Foley Lardner as well. He is in their Milwaukee office, as Jason is. He's a partner and business lawyer practicing general corporate and tax law, and his experience ranges from advising startup businesses to public companies. So we're so happy to have all three of our presenters today. They will speak in turn to their particular area of expertise. This session is being recorded and will be available later for you to share with others and to view again if you need to. The last thing I'm going to say before turning it over to Jason is that TSSA is not telling you that you should apply for any of these programs. We are not advising you, just as these attorneys are not giving you direct legal advice today. TSSA as an organization is not telling you that it is appropriate for you to apply for these loans. You will have to make that decision for yourself. We are not advising you on the steps to take. We're telling you about the laws that have been passed today. So please keep that in mind. These are business decisions like all of the other hard decisions that you've had to make recently, and those will be calls that only you and your partners can make. So without further ado, Jason, how are you today?
I'm great. I'm great. And we're glad to join. We're glad to join Jenny and provide some guidance here and some help where we can. I am going to share our PowerPoint right now. And then as I do that, we can go right to Carrie. And I think we'll start with the labor law issues that we want to talk about. And then we'll go to the financial aspects of this. So with that, I'll just turn it over to Carrie.
Okay, so if you want to get us to the slide on Texas Executive Order, Jason, I'll start covering it. Big picture, Governor Abbott declined
just
to issue.
Second, let me interrupt just for a second. Christy,
Yep.
Please let me know if Carrie is appearing on screen rather than the slides. Otherwise, I'll assume that the attendees can see the slides and she can continue to speak. Thank you, Carrie. I'm sorry about that.
That's okay. Okay, Governor Abbott declined to call what we have in Texas a stay-at-home order, but generally the order he issued requires individuals to remain at home. I'm not sure the vernacular was important, except where necessary to provide or obtain essential services. The general purpose of the order was to minimize in-person contact. So essential services under the governor's order are essentially the federal essential critical infrastructure workforce guidance, hard to say, rules, meaning for you all self-storage is considered a critical infrastructure entity. You're still encouraged, if you can work from home, to work from home. So if the services are essential, which yours are, and they cannot be performed remotely, then you may perform them in person. Next slide, please. Big picture, issues involved for you all mean that you need to be able to minimize in-person contact, remote work where possible, and then if you cannot work remotely, focus on good hygiene, environmental cleanliness, sanitation, and social distancing. That means having the minimum number of individuals on site that should be there and having appropriate sanitation and cleanliness, meaning hand sanitizer, social distancing with customers as they come on and off property. Currently, the executive order from Governor Abbott is in place through April 30th, but you still need to check your local jurisdictions about an hour before this phone call, maybe 2 hours. Judge Jenkins in Dallas County did the Dallas, he's calling it stay in place order through May 20th. And so you still need to check your local jurisdictions to ensure that what the guidelines are for where you are. But again, from what I understand, they're generally following the essential business from federal government. Next slide. That takes care of the stay in place orders. The next slide's about the CARES Act and Families First Act. So questions that we've been getting from clients about these kinds of issues is, what unemployment benefits are available to my employees? Under the CARES Act, employees can obtain an additional $600 per week of funding from the federal government. And they've extended, most state programs are 26 weeks of unemployment. They've extended those to 39 weeks. The good news for you as employers is that this is not supposed to have an impact on your experience ratio. The $600 per week is funded by the federal government. The extra 13 weeks is supposed to be funded in some partnership between state and federal government, and again, not to have an impact on you all as employers. The other issue to be concerned about or to be aware of, depending on the number of employees you have, is the Families First Act. So if you have fewer than 500 employees, your employees are potentially eligible for 2 weeks of full pay, up to caps under the Act for COVID-related leave. They're also potentially eligible for 10 additional weeks at 2/3 of pay, again, subject to caps, provided they need to stay home because their child is no longer in school or they no longer have a child care provider for that child. The Department of Labor recently issued regulations that generally track all of that. They did give us a little bit more guidance for those of you who have fewer than 50 employees. You can seek an exemption. You have to be able to demonstrate that providing the leave required under Families First would threaten the viability of your company. And remember, these issues are potentially all reimbursed by the government, meaning that these are dollars you're going to get in payroll tax credits. I think the department is likely, although again, we have no precedent, to be pretty stingy with this exemption. That's just my thought process. Again, we don't have any way of knowing it. The other issues to be concerned about with respect to these issues are the WARN Act. If you're laying off employees, are you subject to the WARN Act? Do you have more than 100 employees, and are you laying off people in thresholds that would trigger your obligation to provide 60 days of notice? Again, these are unforeseen business circumstances, no argument from me, but big picture, you need to be cognizant of that fact. And then finally, union issues. If you have any unionized workplace, that's something to be concerned about. Not typically an issue in Texas, but if you have unions and you're going to be laying employees off, you need to make sure you're following your collective bargaining agreement and having conversations with your union representatives. And with that, I'll turn it over to the next presenter.
Thanks, Carrie. So I will take the lead here, and Tim will follow on about the tax credits. So we'll talk about the financial options that were provided under the Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act. As I said, I'll take the first two loan programs. Tim will take the tax credits. He'll also talk a little bit about the Family First tax credits. You see here on my first slide, I've actually put together a little chart, right? So all the different provisions under the CARES Act that would apply. Here I was focusing on for employers under 500 employees. There are loans, they're not as good, but there are loans available for those employers who are above 500 employees. We won't talk too much about those today. We want to focus on these programs for smaller numbers of employees. The slides will go much more in depth on the summaries, but one thing I want to point out is that sometimes when you have a chart like this, it's easy to say, or the conclusion you might say is, well, okay, we got to learn about all of these, and then, based on my own circumstances, they'll be a little bit different, or I could be better under one or the other. In general, that's a good thought, but in general, the way that I think you approach it is look at the Paycheck Protection Program, which is the one we're going to go into in detail here, and that's the one that's, for the most people, I think is a very important benefit, and it also needs to be taken care of. You need to go be looking into it today, tomorrow, or on Monday or Tuesday to see if you're eligible, and then to go to the bank and get the loan. So that's the one we'll really focus on, and then we'll move through the rest of these in order. So the Paycheck Protection Program, the Small Business Interruption Loan, and then there's forgiveness. First thing to say about this is that things are changing. The application opened today, 8 o'clock last night. They were sending out the interim final rule, which is probably still subject to some changes as things go on. So things are changing. This presentation, I gave it on Wednesday. It changed from Wednesday to Friday, believe it or not, in some of the answers, or at least some of the things that we don't know or do know. So take everything with a grain of salt. Things may change as things go on. In understanding this PPP, I think some people kind of trip over it because it doesn't fit into what they're thinking is what a loan should be. And you have to understand, this is an economic stimulus package. It's similar to when we all turned in our cars and got cash for clunkers in 2008 and 2009, right? Something like that. It's designed to put short-term money into the economy, and more importantly, it's designed to be to get businesses to maintain their payroll and pay their bills, pay their overhead during this time, especially during the next 8 weeks. So what's difficult as people are considering business decisions is that in good financial management, for every other recession, right, since the dawn of time, if we go into recession, everybody wants to say, you know, what we need to do is furlough our employees. We need to cut compensation, marshal cash, be careful, you know, make sure we have enough cash, and then cut costs. So this program, just understand, it's designed to get you, to incentivize you to do exactly the opposite, which is make sure you maintain employees, make sure they're remain compensated and maintain their benefits, and then keep paying your bills. So I do think in your case, there will be, I think it's a little bit different because of the nature of your industry, but in any case, just understand that's what they're trying to get you to do. And when you think of it that way, when you think of it in context, then it makes a lot more sense. So the way that this works is it's a trust but verify system. So you're going to obtain an unsecured loan. That loan will be up to 2.5 times your monthly payroll costs, when limited by $10 million, or whatever's the lower number there. The thinking is we're going to give you a loan for 2 months of your payroll plus 25% of the overhead. Overhead being mortgage interest, rent, and utilities. After 8 weeks after you've received your loan, and after 8 weeks, you'll go back to the lender and you'll say, if to the extent that I had certain costs, the government will forgive the loan will be forgiven to the extent that you had certain costs. And what are those costs? 8 weeks of payroll, basically 2 months of payroll, and then overhead costs. So if you have those costs during that 8-week period, you can have the loan forgiven. So ultimately, it's not really a loan, it's more of a grant, right? That's the concept, right? If you do what you're supposed to do, which is keep your employees employed and make sure that you keep their paying their benefits and that sort of thing. So let's delve a little bit further into this. Eligibility, you have to be in operation on February 15th, 2020. You cannot have more than 500 employees. This is the big test for people. So we're not counting FTEs. We are counting any employees. So part-time or full-time counts as one. So it's really unclear right now, and it's not even clear under the interim guidance, that what date you use to determine if you're under 500 employees. I think the best answer, although not the final answer, is that the SBA regulations say that you use an average of your payrolls over the last 12 months. So a monthly average payroll. What is really uncertain, and I think the answer is no, as I read the statute as a lawyer, but I do think that there's some room for, some guidance here by the SBA and by the Treasury Department. It appears that the program is, you are eligible for it regardless if you are a small business concern. That's a defined term under the Small Business Act. So if it applies, if a bank decides, yes, we think that that regulation applies, then for your business, I think that the one that I've listed there would be the appropriate one, which means that you would only be eligible for these loans if you have average receipts of, and I have to, I can't actually see that it's 20, I think it's 25 million, but it's listed there on the slide. I can't see it because of the way that Skype is working.
27.5 million.
Okay, it's 27.5 million. So like all attorneys, I have not mastered the new technology. So I apologize. But in any case, the 27.5 million, if that rule applies, I think today I would say that it does not, but I am not certain. The interim guidance did not specifically address this. And I think the position that we've been thinking of for clients is that that rule does not, and I do want to underscore, does not apply. But I think there's some banks that may decide that it will.
Jason, I apologize if you're going to address this later, but the 27.5 million average annual receipts, obviously for a lot of people that won't apply, but that's not cumulative for the whole company. That is for this particular entity we're talking about, right? For this one facility, for example.
Well, no, I think what you would say is that under the if this rule applies, which I don't think it does, but I want to highlight it, is that it would be every entity that's affiliated, and we're going to talk just 2 seconds about what an affiliation means. But if entities, if it shares ownership with some other entity, then you would look to the entire group or all of the affiliated entities. So yeah, it would be the reason I'm pointing it out, and the reason I very much don't want it to apply is because I know it locks a lot of people out of these loans. And I think the way the legislation is written, it should not, underscore not, apply. But I want people to be aware of it in case they go to the bank and frankly have to have an argument. The other part that's a little unsettling to people is that when you make this, when you go to the bank, you apply, the application's actually online, you have to certify, it says you have to certify, check the box and say current economic conditions make the loan request necessary to support ongoing operations. So when people read that statement, and on the application, it's conveniently put right above the statement that says if you commit fraud on this application, you're going to go to jail. It gives people a little bit of worry. It's very unclear what those words mean. Interim guidance did not give us any guidance whatsoever. It just repeated that language. I interpret it pretty broadly, and I think most practitioners are interpreting it pretty broadly. I say that for two reasons. One, this is a stimulus program. So yes, the idea is that we're trying to be a little bit broad about getting money out and into the economy. And then secondly, in the CARES Act, as you'll see when Tim goes through the tax credits, you'll find that some of the tax credits and some of the Family First provisions are far more narrow, right? They actually have, hey, you had to stop your operations, or you've partially stopped your operations. And that language does not appear here. So I don't take this as some concept that if we don't get this loan, we're not going to be in business next week, right? That is not true for most people, hopefully. And so I think even though that's not true, I still think you can make this certification. But certainly, I think you want to take into account your circumstances.
So just to clarify, Jason, looking at that line where it says unclear doesn't require employees not working, semicolon, I used to be an English teacher, complete loss of revenue, neither one of those things are required is what you're saying.
That is right. So it does not require either of those things. We have, the problem as a practitioner is there is no, it's basically the Treasury releases guidance and they just repeat this language. That's why I've quoted it there. They just said, well, you have to certify that you have current economic conditions, et cetera. And so we have not seen anything that has a higher test or a more specific test or anything like that.
Yeah, for what it's worth, in other provisions of the CARE Act, and keep in mind that the CARE Act is one of these wonderful creations of Congress that if you're having problems with your insomnia, pick up a copy because it's 800 pages long. But in other places in the CARES Act, they do talk about people not working or 50% declines in revenue or other similar conditions. And they specifically chose not to with this piece of the legislation. And this portion of the legislation is really one of the cornerstones of the entire act. And it's the one that people are talking about the most and provides some of the most direct stimuli. So we're tending to construe this more broadly, but at least want to be pointing it out to people that when you go to sign your loan application, this is on there. And so you want to be thinking about that. And you would like to be thinking about, and I counseled one client about this morning, to be looking at, well, if you don't get this loan request, are you going to be doing things like closing production lines or not operating facilities and we got more comfortable when we could tie it to, well, we will have more operations if we get the loan than if we don't. And we got comfortable saying in that circumstance that was necessary to support the operations because, well, we were not going to have a second shift running in the absence of the loan. So that was pretty easy in that circumstance, but that at least illustrates some of the line of thinking about what would be different for you if you didn't receive the loan compared to what would you do differently if you do. And to the extent that means keeping people on the job, then I think it's pretty easy that you've met these requirements. To the extent of something else, it requires more thought. But again, we're seeing people be a little more liberal on this than on some other things.
I think so much of what drives our members' concerns is that the other shoe has not dropped yet for them, that, you know, the losses are coming in the near future as we get into the month after the shutdowns. The decisions that people will make in April and in May and what's coming next is what they're most concerned about.
And I think it's important to keep in mind here, as Jason's going to talk about in another minute or two, this is a first come, first serve type of arrangement that is supposed to go through June 30th. But when the SBA makes enough of these loans, then they're done. There's a limited allocation under the CARES Act for it. So we're seeing people line up if you're not certain that you need it. We see people applying for it today and trying to get approved for it today. And if, you know, this is going to take some time to process these loans, you can always decline to take the loan once you get accepted. In which case then, you know, this becomes a largely a nothing for you. But I think as Ginny, as you point out, it's that fear of uncertainty. It's not what does the first week of April look like? It's what does May and June look like? And are you going to have customer cancellations of, you know, either consumers or businesses that are looking to cut costs to say, you know, I just don't need that storage facility anymore. I can save, you know, my $45 a month or whatever that is. And, you know, what does that do? What does that do for our constituency here when you don't know how many cancellations we're going to be? So you don't know what your revenue stream is going to look like. And I think those are all things that you should be taking into account. And, you know, as we talked about having unknown situations and unclear of, well, how is this going to evolve? Frankly, I would err on the side of being a little bit more aggressive on this if you're not sure to be seeking it out.
We had a question come through the chat versus the Q&A, and I'm not sure this is the appropriate time to ask this because I'm not sure if Jason has gotten there yet, but this person asks, they have a lot of part-time payroll with reduced hours of operation. Their payroll is a lot lower this year than it was last year. If my payroll dollars are lower, do I not qualify for loan forgiveness?
Yeah, so I think we'll directly address this later on. We'll go through all the loan forgiveness. Yep. I mean, it really depends. The answer is that it depends really on what FTEs you compared to. So we have that in this presentation. So I think let's.
Okay. I thought you were getting into that. I'm sorry to jump the gun.
Oh no, that's good. That's good.
All right, let's move forward, Jason.
Yeah, let me see if I can find the little. Okay. All right. So I just wanted to point this out. The SBA affiliation rule does apply unless there's an exception, which Treasury has provided some exceptions for hotels and franchisees. I won't go into this in detail, but I do want to point out when you compute at least the 500 workers, right? When you have 2 or 3 different entities, you do have to look at if those entities are affiliated. I put the general rule in here. I don't know if we want to go through it too far. I know that in this business, there'll be a lot of different brother and sister entities. If those are controlled or have the power, if one entity controls or has the power to control each other, or a third party controls both, then you have to consider all of those entities when you're considering whether you're under the 500 number. So when you apply with an SBA lender. You do not apply to the government. even though this is a government program. You apply on Form 2483, although it might be 2438. In any case, it's an application form that you can find it on at home.treasury.gov cares. It's changed about 3 times in the last 3 days, so make sure to get the most recent one. You'll take that to your SBA lender. I think it's important. You probably want to go to your current bank or someone you have a current relationship with. The big key here, as Tim alluded to, is that I'll skip all the way down to the second to the last bullet point there. The program ends June 30th, 2020, if there's money available. So I'll go back, working myself back up through the PowerPoint, right? The applications begin today. The program availability is capped at $349 billion. So loan forgiveness, the maximum amount is $349 billion today. And there's a lot of people who are eligible for these loans and who will be very interested in this. So we do not expect it to, if you come in June 1st, the money may not be there, just to be perfectly honest with you. So you probably need to push it along and get applying and get talking to the bank. These are loans, but they're a little less than most small business loans that you've been aware of, right? There's no collateral, there's no personal guarantee, and there's no showing that you don't have to show that you can't get a bank loan or an ordinary bank loan. So really, this is pretty streamlined. There's not a whole lot of things to prove. The one thing that you are going to have to get ready as you go to the bank is you're going to have to provide documentation to establish eligibility, which includes essentially that you have a payroll. So you do need to pull those things together. The guidance provides, they're really focused on payroll processing, payroll tax filings, or 1099 MSICs, or if those don't work, bank records to establish that you have the employees. Sorry to skip around on this slide here, but the loans are pretty simple. On Thursday, they were at 0.5% interest. They are now at 1% interest. That interest in principal is deferred for 6 months. To the extent it is not forgiven, and you'd expect that most of your loan is going to be forgiven, it will be due in 2 years. You only get to apply once, so you can't reapply. You can't go back for more money in the program. So consider the maximum amount so consider the application you make, maybe think about the maximum amount that you'd like to apply for. My last point there is the application does ask for ownership, and actually for anybody who's over 20% ownership, you're going to need to provide some information there. I apologize. This was for a prior presentation. I forgot to get rid of the not applicable nonprofit organization. So you guys will have ownership. You'll need to detail that in the application when you file it.
Jason, let me add just a couple points as I see a couple different questions. You're not required to use any particular SBA lender. We recommend you use your primary bank because there are so many applications that are pending that banks are prioritizing their own customers first. And I'm aware that some banks are not accepting applications from non-customers. I'm also aware that, checking my emails this morning, I'm not aware of any bank that today is accepting any applications in light of the application changed last night, and there was a bunch of guidance last night that even though they're authorized to accept applications today, I don't know of anyone that's doing so. And a couple of significant banks have told our clients, you can apply on Monday, but they're not going to accept anything today. That's guidance there. Jason, back to you.
Sure. All right. So we'll go to the next slide here. Determining the amount of the loan. This is the key issue, and I think for your industry, it'll be not terribly good news. It could be a pretty limiting issue, right? The amount of the loan is determined by your payroll cost. That's basically it. It's 2.5 times your average total monthly payments during the last year. You calculate this. This is a pretty simple way to calculate it. It's wages of employees who are U.S. residents. It does include commissions and tips to the extent that that's an issue. You can estimate the amount of commissions and tips if it makes sense to do so. But when you're making this calculation, you only include the first $100,000 annualized. So if someone makes $150,000, what you're really going to say is that they make $100,000 a year, divide by 12. and then you'll get your monthly number to put into the amount of the loan calculation. It does, however, it's very broad here. It does include amounts paid for benefits for employees. So group health care benefits, insurance premiums, and retirement benefits. It does include those. It includes any state and local taxes assessed on compensation. But it does exclude credits for sick leave wages and family leave wages. So that's the credits under the FFA. Tim will talk about those at the very end of the presentation. But if you've received credits for someone being out on sick leave, you have to decrease that. You have to subtract that out from your total monthly payment calculation. And here's a sticking point. We didn't know this earlier in the week, but we found some guidance from the Treasury. Independent contractors, so to the extent you are paying someone with a 1099, they do not count. So they are not part of your payroll. The good news is they can go and apply themselves. So the Treasury, this program works for independent contractors, and you can go out and apply for your own, the independent contractor can apply. And then Ginny and I were discussing if you have a storage facility, right, a real estate, and you've hired a management company to run that, that facility, the answer is that this payroll loan or this Payroll Protection Act or program loan will follow the employees. So the management company, which has the employees, it will be able to apply for the PPP loan and forgiveness. And if you had an LLC that had just a facility or just real estate in it, it's not going to be eligible. The good news is that if you own both, right, if you have the management company and you own the self-storage units, then you'd be able to apply. But I think if you own just the self-storage real estate, this program is not going to be for you. It's calculated based on the average payroll for the year before the loan is made. I wish I could say it was the calendar year, but actually you have to go through and do the average payrolls for, here I assumed March 2020, if that's available, but otherwise it might be, March 2019 to February 2020. But in any case, it's basically the monthly average payroll for the year before the loan is made. There are provisions for using different periods if you have a seasonal business. If you had applied for an economic disaster injury loan, I forgot the disaster there, but an economic disaster injury loan, then you can essentially refinance that loan by adding it to the amount of the PPP loan. The overall concept here is that, we'll basically give you 2 months of your payroll costs. That's the defined term. That's what all these things, when you add them all up, that's what they're defined as, right? We'll give you 2 months of your payroll costs, and then we'll throw in an extra 25% for overhead. So that's how we get from, the thinking is from 2 to 2.5, right? Is that we'll also throw in the extra 25% for overhead, which is rent, mortgage interest, and utilities. Okay, sorry. So what can you use the loan proceeds for? Essentially for these things, right? So we talked about payroll costs, which is wages less than $100,000 annualized per employee for their benefits and that sort of thing. And then plus overhead includes interest on mortgage loans. It says not principal or prepayment of interest outside of that, outside of the period. No, it includes interest payments on any debt obligations. It also includes rent and utilities, but those agreements must be enforced before February 15th, 2020. So what's not allowed is you can't go out and with this money decide, hey, I really want to increase I want a better internet connection or something like that. If it wasn't in place before February 15th, you shouldn't be using the loan proceeds to pay for it. It says right on the application, knowing use of for unauthorized purposes is fraud. But that doesn't mean, I just want you to call your attention to it because it is right in the interim guidance. So you do want to use these proceeds to pay certain costs, and you want to be, I would say, tracing or making sure that you're at least accounting for the loan proceeds to be used for these purposes.
I don't know if you saw all these questions that came through. They seem appropriate for right now,
yep.
But subcontractors that are being paid for sales, in self-storage, sometimes there are people who just come in as relief managers, and then they're being paid either, or they're probably not talking about those people, but they're part-time people, and then there are people on the outside sometimes that they're paying for referrals or for sales. It sounds like what you've defined as an employee is pretty strict, pretty straightforward. They need to be your employee. They need to be receiving salary from you, not an outside contractor.
Yeah, I think that just the way that we've gotten guidance from, over the last week, and I think the import of that guidance is that these payments should follow the payroll. So who's an employee? There was a lot of confusion at the beginning of the week and last week, but I think it's gotten far more clear that really what Treasury and the SBA is looking for is for these amounts to be paid on your employees, not to someone else to pay for their employees.
And Jason, is it true that you're going to be required to produce your 940 and 941 tax reports? So you wouldn't have those for those contractors anyway.
Well, that's right. So I think we don't know. So we got guidance last night about the loan part, and it says right in the guidance, the loan forgiveness part is coming. So I guess you got to wait 8 weeks to figure out how it's all going to work. But so
do I take from that,
surprised.
what you just said is sort of like, okay, go ahead and try, but when you see the actual forgiveness part, you may or may not be able to satisfy it?
Well, we'll come back and give another webinar, Jenny. But no, I mean, yeah, I mean that there is a certain leap of faith, I think, that you have to be made. I will say this, I mean, kidding aside, I mean, I'm having read where things have kind of developed. I think it's pretty clear that the Treasury is they're going to be focused on, just as you said, they're going to want the W-2s, the 941s, and they're going to say, okay, any number that's not on those forms, they're probably going to want an explanation for. I expect that's going to be the guidance. Tim, do you have any? Oh, you just
yeah, just swigging the Diet Coke.
Crystal ball.
My expectation is, so the loan forgiveness part, the process that it works through is your lender will certify to the SBA that you've met those requirements. And since you're working with a bunch of banks, and banks are very good at process and very good at checklists and checking things off, my underlying assumption is you're going to need to be able to document those payroll expenses for the 8-week period following the loan. You're going to need to show through paycheck stubs or 940s or some other mechanism, but they're going to want to validate your books and records. And if you can't show it, they're not going to certify it. So we should expect that you need to be able to demonstrate this in writing as to tracking how money was spent.
So I'm going to go through this slide. We have 3 questions. They're actually very good questions. So let's go through them. Let's go through this slide, and then I think we'll talk about the questions we got. Forgiveness to the extent that the business paid or incurred, we said payroll costs and overhead. So the things that we just talked about in the prior slide. But not wages in excess of $100,000. But mortgage interest on other debts, rent, and utilities. It has to be done within the 8 weeks after the loan is made. So it has to be what we call a covered period. But the key thing is, what you can't do is take the loan and, well, you can take the loan and say, we're going to pay, we will have a reduction, right? Or people will be paid less for whatever reason, and we'll have money left over after the 8 weeks. That's fine. You've used the loans for what their purpose is. It's just that you're only going to get a forgiveness for the amounts that you've paid or incurred in that first 8 weeks in the covered period. You can still use the loans for something else afterwards. It's just that it's not going to be forgiven. That's all. You'll just have to pay it back. The the SBA Treasury is now saying that non-payroll costs, so the things that are overhead, interest, rent, utilities, in excess of 25% of the overall loan amount will not be forgiven. They've that's not in the statute, but they've essentially said, I've seen that go from may not be forgiven to basically will not be forgiven.
Yep.
Amount not to be not forgiven remains a loan 2 years. And here again, on Wednesday, if you would have talked to me, it was 0.5. Now it's 1%. So get your loan application in. I mean, I think it goes without saying, Jenny was alluding to it, right? I mean, maintain the documentation, because just as Tim said, these are banks. They're going to want, when they certify this to the government, they are going to want some heavy documentation. So you definitely want to focus on that as you go through this 8-week period and then trying to get the loan forgiven. So Tim, maybe we can go through these questions. I think they're appropriate now. Okay, what if you have no employees? Does this program still apply for expenses? I think the answer is no. I mean, I think you're just not eligible for the PPP, as unfortunate as that is. The eligibility requires employees. So that's just the way that the government has chosen to do stimulus this time around.
Jason, may I interrupt just for a second?
Oh, please.
So if the facility owner runs the facility, which is the case in some cases, they have no employees, but they're actually running the facility. If they pay themselves a salary, do they then become an employee?
So, boy, I think the word in the statute is employee. So I think the answer is that if they are receiving a W-2, I think they can consider themselves an employee. But on the flip side, So there are provisions that allow independent contractors to receive. Oh, go ahead, Tim.
Let's move on, and I'll see if I can look that up while we continue on.
Okay, so you stumped us. We're going to take a look. We'll see. If you have an employee that you 1099, can you add that person? That's a little tricky because you have to come into it and say you have certain employees as of, we said February 15th. So could you add that person? I'm assuming that means could you add them as a W-2 person at the current time? I think the answer is going to be no, because you have to have employees, and then we're going to go back when we look at reduction and find that you're going to look at your FTEs who are employees back, in the prior period, and you'll have 0. So I don't think that's going to work. Let's see here. Although it may be worth digging into a little bit. If the management company receives the monies for the employees, then those utilities are allowed to be paid, the properties or the utilities for the management company.
Whose
utilities?
Not
go ahead.
those utilities, but whose utilities? I think she's trying to clarify whether, obviously the utilities expense is going to be incurred for the facility itself. Right.
Yeah, I think the tricky part there is that I think the answer is going to be that, and it's really unclear. So we have seen no guidance as to if you have 2 affiliated entities, which would be really common. A lawyer would have told you to do that. Put the facility in one LLC and put the management company in another LLC. That's a totally common thing to do. The management company is going to apply for this PPP loan. And then the question is, can you take the PPP loan and apply it, those monies for pay the utilities for the facility? It's not clear to me. I guess I would
just
say,
don't have guidance on that yet.
Yeah, we just don't have guidance. So we'll see when it comes to the forgiveness part if they've understood at the SBA that people have different business entities. So that's what we have. I don't think you could rely on getting the loan forgiveness for that amount. As a third-party management company, many of our payroll hours are billable to the facility owner. Please explain how this will affect billable labor hours. The answer is if they're your employees, even if you're billing them out to someone, then you're going to be able to apply for the PPP. It doesn't matter that someone else is paying for them. This is just strictly a concept of, you having employees and you having payroll. If an employee is terminated for cause during these next 4 to 8 weeks, will this result in a breach of the loan? It is not a breach of the loan, but the next slide, we're going to talk about reductions of loan forgiveness, and it could result in some reductions for loan forgiveness. So let's talk about that actually on the next slide.
And just to remind people to use the Q&A feature rather than the chat to ask your questions, because the speakers, the presenters are seeing the Q&As come through, which is what they're reading from. One last thing on the point of management companies, Jason, because I think we've had a lot of questions about those in advance of the webinar, and those people are on. Really, I think you know this already, but at the end of the day, the question comes down to this: who's entitled to the money? You know, the facility owner owns the facility. Even though the management company hires the people who work at the facility, they essentially work for that owner through the third-party management. And the utilities, as you've mentioned, you know, are incurred by the facility itself. Maybe the management company pays the utilities, maybe they don't. But I think that's the core question, is, and that's maybe outside the scope of this presentation, but, you know, who's entitled to the money when it comes in from the government? So it's kind of where I see this.
Yeah, the answer there is, you know, the forgiveness of the loan goes to the party who obtained the loan. Obtaining the loan is based on that party's payroll, not the payroll that's on a third party's tax returns that you may economically be liable for, such as by contract, or that's part of what your service agreement is. Unfortunately, the way the stimulus works, it follows where does the payroll. And the guidance that Treasury and SBA have given us so far, that's sort of the thematically of where this is going, is they're following the payroll. So if they're not your employees, even if you're responsible for it, unfortunately, you're not the party that gets the benefit. And conversely, if it's your employees that you're charging out to somebody, you're the one that should go apply, and you're the one that would get the benefit.
And I'd go even further. I'd say if you own both the management company and the facility, like,
yeah,
I would
aggregate
loan with the management company. I mean, I would not try to explain to the people at the bank how that contract works. I would be whoever's got the EIN on the W-2s. That's where I would. That's the approach I would take.
And Jason,
if I had two management companies, I would apply for loans with through both management companies.
and did you see Clint's question come through about that, Jason?
Okay, based on your recommendation, a company with employees need to be the entity to apply. Is there clear guidance saying doing the other way, the owner applying will not be allowed? No, there is no, it's all speculation. So that's right. There is no, so far as I know, there is no even contemplation, right? Nobody's ever thought about if two entities work together and maybe they have some sort of employee sharing arrangement or management contract, all those things that everybody's very familiar with. There's just no guidance on it whatsoever. The best we can do is that we just see, I mean, I totally agree with Tim. From what I've seen, it just seems that they're going to be focused on who's the number on the EIN, or sorry, the EIN on the W-2. Okay, so actually there's two questions in here about reduction. So I'm going to kind of get the general gist here for you, and then we can circle back if there's any questions. Remember, the whole idea of this program is to make sure that you don't reduce payroll during this time, right? So we're going to say if you do reduce payroll, you don't get your loan forgiven, right? You have to pay it back. So first, there's a reduction for the loss of FTEs. The concept being that you have to maintain the average number of FTEs during the eight-week period. So you'll compare the average FTEs during the 8-week period compared to prior periods of either February 5th to June 30th of last year or January 1 to February 29th of this year. So, you know, the questions of, well, if I fire someone for cause or someone is laid off or they quit or something like that, this is a very mechanical test, and it doesn't take into account anything that else may happen with the business. So the concept will be if someone is terminated for cause, for example, then you're going to get a reduction unless you go out and hire somebody to replace them, right? That would be one solution to it, which would incidentally, I think, be part of the intent of what they were trying to get here. In addition, if someone was making less than $100,000 and their wages go down by more than 25% for whatever reason, that's going to trigger a reduction as well. So the amount of the forgiveness is reduced. Sorry about the nonprofit there. So just any corporation decreases salary and wages by more than 25% for any employee who is making less than $100,000. What you'll see is that you get a reduction for that as well. There is one provision basically says that if you've already been laying people off or giving them furloughs since February 15th, you have 30 days after the date of the act. You have to rehire them by June 30th, 2020 to avoid a reduction. So if you have made reductions in this period of time, I think it's since February 15th to the 30 days after the enactment. So it's going to be somewhere, I think, April 26th. You can rehire those people by June 30th, and that will allow you to avoid a reduction on layoffs and furloughs that you've already done. We have some, let's see if I can find if we have a few questions in here. So Karen said if an employee retired at the end of February and we had a new hire in early March, would this payroll be deemed ineligible? No, I think your payroll amount, right? The amount of the payroll loan going back 3-4 slides is based on this payroll is it's depending on the amount of the loan is dependent on your payroll over the last 12 months on an average basis. So I guess the new hire in March may not be, I guess it would be part of the average for March if you were doing it that way. But the employee who retired at the end of February, he or she would be part of that average for the 11 months before then. All of our employees and owner employees are independent contractors. The owners are paid by bank transfers. So the owners who work considered as 1099 employees, I think they're probably not 1099. I think if everybody's an independent contractor, I think that's you're basically thinking there that they are not going to be eligible for the to be put into the amount to be the payroll loan amount. I think that's the way to say it. So because they're not employees, I don't think they're going to be eligible to be put into the payroll loan amount. Does that make sense?
Yes, but people are still hopeful, so they're going to.
I know. If you ask it enough, the thing with this guidance is that if you ask it enough, you might actually get a different answer. So I don't blame you for trying. That's for sure, because it's changed so much. Other points, I'll just reiterate: the amount of the program is capped, so don't delay. I mean, really be talking to your bank about this. I think there's been some delays in processing right now, but this is up and going. It's really $349 billion, and you want to get in. I think it's going to be it is first come, first service. First come, first served. And then also do remember, although I just called this a bank stimulus, stimulus bill, right? Do remember your current bank covenants still apply. It is a loan. And so remember that you may be triggering provisions in your current bank covenants. That's one of the reasons why it's better to go to the bank that you've been currently using, right? Because they know about the covenants and are able to waive them a little bit more expeditiously, but you do want to take a look at those. So going back to our chart here, we went through the Paycheck Protection Program. I do think that's the very first one to focus on, especially as quickly as possible. The other three we'll talk through a little bit. We'll talk through all of them actually, just a little bit less in detail. But you do want to focus on the Paycheck Protection Program. So now to the Emergency Economic Injury Disaster Loan. This is actually a program that exists now. If you've ever been caught in a hurricane or some other disaster, this is something that is always available. It's just been expanded for our purposes today. You apply it directly online, and you can do that today. The application is open. To the extent that you have applied for one of these loans and you have received the cash in the last month and a half, you can refinance it as a PPP loan, right? Because this one won't be forgiven. The PPP will be. Nonetheless, what you can't do is apply with some costs to the PPP and then essentially take those costs and claim them as a substantial economic injury on an application for the emergency economic injury disaster loan, right? So you can't double dip. You have to be careful about that. If you had costs that were separate, you might be able to, but you're not going to be able to get loan forgiveness for a cost or for a loss under the emergency economic injury disaster loan while at the same time paying the loss with the PPP loan forgiveness. These loans are they're quite a bit harder to get. You actually have to prove that you've received a substantial economic injury, right? So you have to point to be able to say, okay, well, and I talked to a gentleman yesterday, his business is basically kaput. He cannot run his business, and he can point directly to, all right, well, this disaster caused this loss for me. These loans are limited to $2 million. You can get an advance of $10,000 that does not have to be repaid back. It does have to be paid. The interest rate is 3.75 for businesses. There's, again, no forgiveness. There's a 30-year term, so you do have some time to pay it back. If the loan is in excess of $200,000, you do have to issue a personal guarantee. And then this loan is actually subject, unlike the PPP loans, the SBA is going to have to make the determination that the applicant has the wherewithal and the ability to repay the loan once things get back in order. And I think with that, Tim, I think that's the loans, and I think we can go to the credits, the tax credits.
All righty. So the first of the tax credits is an employee retention credit. This applies, and we get a little bit different rules depending on what your organization is. Again, this is intended to give you benefits in the extent that you are paying employees. These need to be your employees, not somebody else's employees, that we're going to have some of the same issues with management companies and affiliates. But this is not part of the, this is not generally connected to, and it's a different set of rules that apply from the small business loans. Basically, if you're an eligible employer paying qualified wages, I put air quotes around those because these are defined things, then you can get a 50% refundable tax credit for these amounts. So it can produce a pretty substantial savings for you, but how substantial this is going to depend a lot and vary massively from person to person. Key thing is if you get one of the payroll protection loans, then you can't get this. And conversely, so if you get the payroll protection loan, the idea is that this credit is to cover people who are paying for things, and if you're getting the payroll protection loan, they view it as that's already covered, and you shouldn't get a double dip. To be an eligible employer, again, these air quotes, you have to be in a trade or business. For most of you, that's not really a problem. It becomes a bigger problem if you're a nonprofit. And then you need one of two things. Either you are fully or partially suspended due to government orders. I'll call that a suspension, or sometimes a stay-at-home type of order. And we'll talk about more of that in a minute. Or alternatively, you need more than a 50% decline in your gross revenues in a calendar quarter compared to the prior calendar year. So if your gross revenue was 100 in the second quarter of 2019, your gross revenue would need to be below 50 in the second quarter of 2020. I'm expecting for a lot of our constituencies on this call, these things aren't likely to be, you're not likely to have that 50% decline. There's a bunch of additional rules on that decline that also apply about, well, when does it stop? For brevity purposes, we're going to skip over most of that today. So if you're not an eligible employer because one of these two things hasn't happened to you, then you're done with this credit. If you are an eligible employer, then we need to go to the next slide. Jason, you can hit that. Okay, so the next part of this is figuring out, well, what exactly is a qualified wage? Here we get a different set of rules based on how many employees you have. If you're a smaller employer, 100 or fewer employees, it's one set of rules. It's more favorable for the smaller guys. For more than 100, and it doesn't matter how many more than 100, it's a much more restrictive set. So let's talk about the restrictive more than 100 employees. You need to be paying wages to an employee who is not performing services, i.e., and that needs, the reason they are not performing services needs to relate to your suspension or gross receipts decline, i.e., you need to be responding to some sort of government order or you have this gross receipts decline. And again, I'm going to assume that that doesn't apply to our audience here. And so you need this correlation. Now, to the extent you're an essential service, that makes it a little bit more problematic about, well, whether this is going to pick or apply to you, because this needs to be for not performing services, i.e. someone that you put on furlough that you're paying anyways. So an example of this might be that you, as a self-storage company, you have a front office that's normally staffed and you have a receptionist or a person attendant there. But in order to comply with the not stay-at-home order, but still Governor Abbott's order, you decide that that's not essential to have that attendant there, that you can still operate and you can have the gates open or allow people access, but you can get away with, and in fact, you determine you're required to not have that attendant. And then you decide to pay them wages anyways, whether that's full wages or partial wages, because you'd like to make sure that they're willing to come back when we get behind the COVID response. Then you qualify for the wages on them. Again, there's a few other strings we'll talk about in a moment. So again, that key thing is you got to be paying them for not providing services. If you're in this group that's less than 100 or 100 or less, then it doesn't matter whether they provide services to you or not, as long as you continue to pay them. If you have, your facility standalone, it has 20 employees, then as long as you're paying people and they otherwise meet these requirements, and you've had a partial slowdown or partial suspension, then in fact you are going to be eligible, even if it's for people that are still showing up and performing services on the job. For purposes of measuring employees, there is a set of rules under 4980H of the Internal Revenue Code. I'm going to confess to you, I am kind of a code junkie, but until last week, I didn't know what that was. That's the rule that applies for figuring out healthcare benefits under the so-called Obamacare. So, and it's a pretty expansive set of rules that casts a wide net. So basically, it's going to pick up most versions of affiliates. Okay. Next slide, Jason.
Yeah. So Tim, I think Jenny's telling us we gotta maybe 10 minutes. Jenny.
Yep. We'll finish up quickly. Okay. So as far as what wages go, they need to be wages within the meaning of the FICA rules, i.e. taxable compensation generally reported on a W-2. But you get the bonus of including any employer-paid healthcare, including any pre-tax deductions the employees make. But the important thing here is also you have to exclude any of the qualified sick leave or qualified family leave that's provided under the Families First Act. There's a different tax credit that applies to it. It's actually better. I'll talk about that in a moment. And there's a limitation that says it's $10,000 per employee for the duration of the program, i.e. for any particular employee, the best you can do is get a $5,000 tax credit for compensation that you've made to them. So there is an outside limit that applies to this. Next slide. All right, so the way the mechanics of this work is you get the benefit of this credit at the time that you pay payroll. So normally you pay payroll and either the next day or within 2 weeks, you need to turn over to the federal government the employer part of FICA, the employee portion of FICA, the federal income tax withholding. This credit can be applied against all of those obligations that you would submit with your payroll, any of the tax obligations you submit to the government. So if I've got a credit of $5,000 after I run this payroll, I can reduce the aggregate amount that I pay to the government, to the federal government, by that $5,000. If your credit exceeds what you owe to the government, you can carry it over to the next payroll period. And you're also allowed to, if you prefer, that you can request a so-called quickie refund from the government. They say that they will make a payment to you. They're supposed to process this on an expedited basis. You know, how expedited that really is, I don't know, but we're told that it's probably be a matter of weeks, not months. But most employers I'm talking to are looking at just carrying it over, or are anticipating the amount of the credit won't exceed their obligations to begin with. But you do get a benefit, and it hits your cash flow awfully quick in the form of reduced payments to the government when you make your payroll. Okay, I got one question so far. Management companies typically use professional employer organizations. We don't really know the answer of how, either for purposes of the SBA loan or for the purposes of this credit, professional employer organizations are going to work. That's one of the things that we've made inquiries to the SBA about, and we're hoping that that's something that we get guidance on. But at the moment, all we can do is speculate on how it works if you're using a professional employer organization. Unfortunately, I know, I'm sorry, that's a sad refrain or a common answer, but you know, this program didn't exist 8 days ago, and everybody's figuring out the rules as we go along. And as not surprising, the way people handle payroll is frankly, it's complicated. We've all created lots of arrangements for different purposes, and the drafters of these rules just didn't anticipate all of them and when they put it together. Let's go to the next slide.
Hey, Tim, one thing I can throw out there on that point is we, the association, use a PEO, and I know that they're sending us material. So they're obviously, the PEO itself is all over this and paying attention to the rules. And I would suggest, Todd, you reach out to them and see what clarification they have received. I know I received some things this morning from our PEO, and they're having to figure this out too.
Okay, thank you. Can you get back to the slides, maybe?
I think we might have lost Jason.
Okay.
And Carrie, you're muted, but Jason, I think, might have dropped off, and hopefully he'll reconnect because he is our slide guy. And unless Christy or Teresa can get to the slide that we left off on and put it up for us, we're in a little bit of trouble.
All right, well, we'll continue without the slides. You can look at some of our pretty faces. But in any case, so the next item that I at least want to flag for you is somewhat different. And this is much more generally applicable, that basically all employers can have a deferral of the Social Security taxes, the employer portion of Social Security, i.e. the 6.2%.
Hey, Tim.
Yeah.
Can I interrupt you just for a second? I'm going to stall just for a second because I think this is very critically important, the part that you're about to go into. I think it's the kind of thing that needs to have the slide up for it. Okay. And Christy is about to share that. She's got it coming up right now. She's going to slideshow back up. I think we're pretty far into it, Christy.
I think we'd be slide 22.
Thank you. And while we're waiting for that to pop up, just a little note. Zoom had 600,000 downloads last Sunday. And I mean, it tells you something. Part of what happens with Jason, for example, dropping off is they're giving us warnings that there's lag and there are issues and internet. It could be something simple like his computer died, or the device he's using ran out of batteries or something, but it could also be that he dropped off just because of lag and because of the tax on the Zoom system. So
I'm going to blame his really cute little dog.
The dog
probably did this.
Yeah, the dog knocked the power cord out or something. So anything could happen. Can you do a slide view on that, Christy?
Yeah, it's up on my screen.
Okay, well, we've kind of got it on the view where.
Oh, I see. Okay.
See the side slides in if you go up to slide, and that should work. We'll work with this.
Okay. So for the employment tax delay, again, this is the employer portion of FICA taxes, the 6.2%. This is generally available to all employers, regardless of your size. And it says the obligations that you would normally make when you file your payroll or within a short time thereafter. It's deferred and is payable in two pieces. One is at the end of 2021. The second is the end of 2022. And this one applies to wages starting the payment date was on or after March 27th through the end of the year. The other good caveat that goes with this is if you receive one of the payroll protection loans and you have that loan forgiven, then you're not eligible for this benefit. Treasury is supposed to provide guidance about, well, what happens if you start deferring these payments and then later you have a loan forgiven. They have not done so yet. I expect what's going to happen is because you'll have a loan forgiven that this will become due basically immediately. But you know, in the meantime, since you don't know whether a loan will be forgiven, I'm not above trying to claim both unless and until the loan is actually forgiven. So again, no size requirements on this one. And there are some rules for dealing with if you're using a third party payroll agent that says they're allowed to defer payments that go to the government, and it relieves them of responsibility for if you direct them to defer payments, i.e. so, you know, if you're using a payroll processing company, you can reduce this by the amount of these employer side payroll. You can reduce the amount you pay to them, so you get the benefit of the deferral and not your payroll provider.
So Christy, if you go to slideshow and then show current slide, oh, she said her screen is freezing up. So there you go, technology working for us in our best interest.
There you go.
Slideshow it, there you go. Here it comes.
All right, and let's go.
Ask one point, Tim. Can I ask one question about the Social Security tax? So ultimately, you're still going to pay them. You're going to end up being responsible for the Social Security taxes. This is just a deferral. So you're not going to get out of paying them.
Yep, there's no cost savings other than time value of money. But, you know, cash flow is kind of king when we have challenging times like we do right now. And deferring an obligation to next year or the year after, it's just a form of a, you know, a zero cost interest-free loan. So we're seeing everybody who's eligible for it. I'm generally seeing people taking advantage of this now.
Okay. And I think Jason is back with us, but we'll try to keep.
Sorry about that, Jenny.
No problem. We're blaming it all on technology and Zoom and the tax
and
on
the dog.
Christy was able to put up the slide from her screen, so we've got it up right now. Jason and Tim will keep moving on from here.
Yep.
Okay. Why don't we go to the next slide? So we mentioned before, and Carrie talked a little bit about these extra benefits that you're supposed to provide under the Families First Act for the qualified sick leave and qualified family leave. To the extent that you in fact make these payments, there is a 100% tax credit that's available, so that those are new obligations imposed on you, but at the same time, the government turns around and it gives you an opportunity and a mechanism for paying them. This uses the same payroll mechanism that we just talked about for the other tax credits, so that if you are making these qualified leave payments, you're going to claim the benefit for it on your payroll tax return and get a benefit for it immediately. And again, to the extent that the amount of the credit exceeds the payroll withholdings and the employer obligations on payroll, you are eligible for a quickie refund. So again, this is actually pumping cash flow back to our constituency, again, to the extent that you're incurring these expenses. Okay.
Next.
And then as far as some other tax benefits, at least to flag for you, if you're generally there are rules that relax the restrictions on using net operating losses. Previously, we were banned from carrying those back due to the 2017 Tax Cuts and Jobs Act. And at least for this year and for 2018 and 2019, to the extent you had an NOL, you can carry that back up to 5 years. And there's no 80% limitation on the use of the NOLs for those years. So if you've had a loss in one of the prior years, you can go get a refund for it now and get free cash flow for it. To the extent 2020 is going to have an NOL, you're going to have to wait until the end of the tax year to get a claim for that. But there is a process for a quickie refund for NOLs, and that is a long-established IRS process or procedure. It's been dormant for a couple of years because it hasn't been applicable, but we expect the IRS will dust that off and will provide for additional funds, or provide a mechanism to get cash in your hands relatively quickly. There's also, for individuals, there's some relaxation on restrictions for so-called excess business losses. Again, this is retroactive 2018-19. So to the extent you had some of that apply to you for prior periods, you can file refund claims. And again, you can get more immediate use of funds. Let's go one more slide. And this one might be a little more interest to this group, which, or excuse me, I guess there's two more slides. One is if you're a corporation, there's relaxation on AMT credit rules. Those were supposed to be the use of AMT credit carry forwards, if you had them, was supposed to be phased in over a number of year period. Now you can fully utilize them in 2018 or 2019, again, creating an opportunity to go file a tax refund if it's applicable to you. And likewise, there are some restrictions on, there's an interest rate restriction that basically said no more than, through a big formula, no more than 30% of your modified income could be used for interest deductions. That also has been retroactively relaxed for 18, 19, and 20. That 30% is 50%. So again, if you were subject to the interest rate restrictions in 18 and 19, you can go file a refund and get, again, free cash flow for that back. Those are temporary relaxations. In 2021, it goes back to the prior rules. One more slide. And then the last one here is, and this is applicable for our constituency here, of fixing the so-called glitch that limited bonus depreciation on real estate improvements. The fix to the glitch, this was left out of the 2017 Act, presumably inadvertently, but Congress did go back and put it in retroactively. So if you've had real estate improvements that you made as opposed to purchased in 18, 19, you can go get a refund for those, as well as to the extent that you're doing self-improvements to your property. This year, again, you're eligible for that bonus depreciation. And to the extent you don't claim bonus depreciation, these get a 15-year life instead of a 39-year life. So we're finding that's a big benefit for people that hold real estate or rental real estate, or even, in fact, leasehold improvements. If you're leasing your property, like a ground lease or something like that, that there's some meaningful advantages to you there. And again, there's not a lot of specificity. We're hoping Treasury releases some guidance short of making you go and file amended tax returns for this, because this is a pretty widespread item. But we're hoping for a little bit more guidance from Treasury. They have a lot of things on their plate, so I'm not holding my breath that that's going to happen immediately. At least I'm just going back through the questions. There are some questions about, well, are there other SBA loans? There are other programs that we didn't fully talk about in this presentation. I confess I'm not an expert on everything. As you know, we're kind of learning some of this as it goes. The question was, if you had an existing loan, is there a deferral feature in it for 6 months? My memory is yes, but I am not authoritative on that, and we need to go back and validate that. I just don't remember those rules well enough for some of the existing programs. I will say that the SBA is very aware of people that have taken loans out earlier in the year, immediately before this, and much of their guidance is aimed at providing relief of, you know, if you closed on an SBA loan in early March, of not being unfairly disadvantaged because you closed on it earlier in the year than some of these other programs. So I know they're very cognizant of that, and they're trying to work for relief that goes with some of these quirky rules. The last point that I would make, if there aren't any other questions, on our website at Foley, we do have a Corona Resource Center that our attorneys, and we're a large law firm, we have over 1,000 attorneys nationwide, that we get lots and lots of different questions about all kinds of different things related to Corona response. We've been trying to aggregate our information and make that freely available to the public. So you're welcome to click on our website. The link is here. If you go to our website, foley.com, it will pretty quickly steer you to the Corona Resource Center. On any particular day, there is 5 to 8 new articles that are posted. Many are about topics that might not be of interest to you, but maybe they are. There's also a search feature that you can go through by topic as well as term search, so that you can go back and you can check on things that may be relevant to you. That kind of assembles some of the advice that we're telling our clients. There's more information about the SBA loans on there, as well as a whole host of different things of other tax things, benefit results, breaches of contract and force majeure clauses, a whole host of different things. So I'd encourage you, you're welcome to use it and share that with your friends. There's no obligation to us, of course, for doing it. It's something that we're just freely making available to the public.
And again, we will be posting this recorded webinar, and we will also send it out. Once Zoom finishes the recording, they compile it. It takes a little while, and then we will actually send that out to all of our attendees, all of our registrants today. And with your permission, Jason and Tim and Carrie, we may also be able to link to some of these resources right from our site.
Of course.
Absolutely.
We've kind of created a place for members to go with coronavirus resources, and this has been a great one. Really appreciate your time today. I think that there might have been one more question. Well, we got that one. I think all our questions have been answered, which is wonderful. And we're running fairly long, so I think we'll go ahead and wrap it up. Thank you to all of you for being here with us today and for answering the questions so succinctly. We really appreciate it. And once again, we'll post this after the fact, and everyone stay well out there. Thank you so much.
Thanks, Jenny. Thanks, everybody.
Thank you.